FOX6 Studios. This is Ask Contact 6, and this is the segment where we bring in experts to answer your questions. Today, we are talking about landlord-tenant issues, and this is something we hear about a lot at Contact 6. We hear about your problems with security deposits, property conditions, eviction notices. I could just go on and on, actually. But Contact 6 actually doesn't handle landlord-tenant complaints. We do consumer refunds. So we thought it would be a good idea to bring in two experts today from Legal Action of Wisconsin to answer your questions. And we have Brittany Shanick here and Aubrielle Newman. Thank you so much for joining us.
Thank you so much for having us.
Yes, thank you.
Oh, of course. Now, before we get started, would you mind telling me a bit of your professional background, the work you're doing at Legal Action of Wisconsin to help tenants?
Sure. So Legal Action of Wisconsin is a nonprofit law firm. We operate in 39 counties in the lower part of Wisconsin. Aubrielle and I are both staff attorneys in our Milwaukee office, and we focus primarily in helping tenants with their legal issues.
And you have an eviction defense project, right?
Yes, we do. So I primarily work with the Eviction Defense Project. So we are at the courthouse in room 400, right outside when court is happening. So we help otherwise unrepresented tenants who are coming there without representation have an attorney for free at their hearing. So we're there on every Monday, Wednesday, and then every second and fourth Friday of each month.
And I assume you must be really busy based on the amount of complaints we get about landlord-tenant issues. I assume you must hear a wide range of issues.
We really do. Yeah. So thank you for this opportunity to help answer some of the viewers' questions.
No, thank you for coming in. We're going to get to those viewer questions in just a moment. But first, I'm happy to say we have gotten so many submissions. So thank you to everyone who took the time to fill out an online form. We're going to get to as many of those questions as we can, but we do apologize if we don't have enough time to get to every question today. Hopefully, we'll ask a similar question, and that issue will be discussed here. A couple notes. We did paraphrase some of the questions that were on the longer side, and Brittany and Aubrielle, of course, will do their best to answer your questions based on the information that we have. But of course, for advice on a specific situation, you may want to seek guidance from your own lawyer to get the best advice for all the particulars of your case. Now, I'm excited to get going. Reading our questions for us today, we have our Contact 6 associate producer, Annette. Annette handles all of our off-air resolutions, so if you've ever emailed with our segment or you've talked to us on the phone, chances are that is with Annette. So Annette, thank you for all your work. Can you start by reading us our first question today?
Sure, Jenna. Our first question comes from Tracy in Port Washington, and Tracy has reached out to us with the following. We just signed a lease renewal. The rent is paid every month. The landlord called and said she wants us to move now. She says she never should have renewed the lease because she can get more than what she is charging us for rent. She's giving us 60 days. It's a generous amount of time, but is it legal? The only reason I doubt I will fight this is because I don't want an eviction on my record. Even if I win, it will make it harder to rent in the future.
So if I'm summarizing that question, it sounds like she's asking, can a landlord rent or evict someone in the middle of a lease if they haven't done anything to violate that lease?
That's a great question. And so for a lot of these questions, our advice is going to be to always check your lease document. Check any agreement that you've had in writing with your landlord. If you don't have a lease agreement or anything in writing, that's okay. You're still a tenant. But if you do have something in writing, you always want to check that to see if there's any provision or clause in there that would address, in Tracy's case, breaking that lease mid-term of the contract. So if there's not a specific lease provision that would allow either party, either the landlord or the tenant, to break the lease early, the answer is likely no. That no, a landlord can't just break the contract mid-lease.
Because they felt they could have gotten more money from someone else.
Correct. Absolutely. Another interesting point that Tracy brings up is having an eviction on your record.
Right, because that can have long-lasting impacts even if it isn't something that is followed through on, if she isn't actually evicted. Is that true?
Yeah, absolutely. So the mere filing of an eviction lawsuit is publicly searchable. And so like in this case, if Tracy isn't actually evicted, right, just having that mere filing, that's a public record, can really harm her ability to find safe and affordable housing. Landlords might look at that mere filing and deny housing to her. So Tracy does bring up a good point, and unfortunately there's no real good solution to that that issue right now.
And I believe that would remain on her record for a couple of years at this point. I think we just did some stories about that, so I believe that's the case. It could be on there for a couple of years.
Yeah, so Tracy is in Port Washington, which is Ozaukee County. Every county is a little bit different with their standards on what they could petition a court to seal their name for based on. It's probably likely that if the case is dismissed, she might be able to get it removed after a couple of years.
Okay. Annette, I think we've answered all the questions that Tracy brought up. Would you move on to the next one?
The first one is from Jody in Kiel. Jody writes, the neighbor in my apartment building has a dog that barks when they're not home and it's annoying. Sometimes I work from home and I'm on Zoom calls. The manager won't do anything and it's a violation of the lease agreement. Also with the noise issue is Melissa in Milwaukee, and this is what she writes to us. I live in a 2-family townhouse. My neighbors have an autistic young man that when the other adults are gone, he beats on the walls all times of the day, at night and into the wee hours of the morning. When he's not banging, the dog barks. I have complained to the property manager, but he says he has no solutions. I'm a dialysis patient and I'm losing sleep because of the constant noise. This has been going on since last year.
Okay, so what can be done if you have noisy neighbors or dogs and you're all renters maybe in the same building?
Yeah, so this one's a little bit more difficult because it's not an issue that you're necessarily facing with your landlord, but it's with other tenants in your building. So I kind of want to preface this answer by saying that, you want to be careful with the complaints that you make to a landlord, because anything that you say as a tenant to a landlord can then affect someone else's tenancy as well. And that's just something to always consider when you're trying to address these issues. So really, what we think would be the best way to start would be, if you feel comfortable, you should talk to your neighbor about the resolution. If you can talk to them about their dog being loud or about other members of their house being, disruptive during the day, talk to them and see if you can come to a solution then. Then if that doesn't work, that would be the time to speak to your landlord. It sounds like some of these folks have already done that sort of thing. So, you're making a good step by asking someone to try to step in to mediate that as well, and to always have that documented, to have that in writing. Because the next step would be, if that doesn't work, then you would want to, consider your option to break your lease. So the law does allow, if you're living in, conditions that are, perhaps not uninhabitable, but there are options for you to be able to break your lease. But you'll always want to, as Brittany had mentioned, in our former question, there are oftentimes provisions of a lease that are very specific. So you want to make sure you're doing that correctly. So that would be the next step. So if it's not something that you can resolve between you as neighbors, as co-tenants, and it's not something that the landlord is willing to fix, you would want to take the next steps to legally break your lease.
So maybe according to your contract that you have with the landlord, there would be an out for you if there was a circumstance like this where you can't sleep at night?
Exactly.
Okay. All right. That's good to know. Annette, I think our next question is from Amanda in Milwaukee.
Yeah, she has reached out with this question. Can a tenant prematurely break a lease if a home becomes infested with mice and bugs?
Okay. We hear about this constantly at Contact 6, and we often tell people, contact the Department of Neighborhood Services. Is there another route they should be going? Who should they be talking to, and can they prematurely break their lease if this issue is not going away?
Yeah, we hear about infestation issues all the time, and it's really a huge health and safety issue, especially if you have anybody who's immunocompromised living there, or even small children. So number one, our advice is to always document. When you move in, if you're noticing that there is an infestation issue, document that. Take pictures with timestamps. Make sure you're letting the landlord know that, hey, there's this issue here. There are bed bugs, there are roaches, there are rodents. And then it becomes, on the landlord to do something. And if they're not doing something, or let's say they're just setting traps, but they're not really addressing the root cause of the infestation, then certainly reach out to your local building inspector. In Milwaukee, that's the Department of Neighborhood Services, otherwise known as DNS. And they'll do an inspection. And they can issue an order to correct to the landlord. The landlord has to, promptly provide repairs. If they don't, and if the tenant hasn't actually caused the infestation themselves, then the tenant can leave. They can break their lease. They can, leave, because that's an issue where it's affecting health and safety. So it can be difficult to prove sometimes if the landlord, knew about it before the tenant moved in, if the tenant caused the infestation. So our advice is to document again. If the minute that you find out that there's an infestation, take pictures. Maybe talk to other tenants in your building. Have you noticed this issue? It might be the case that this has been an issue that's ongoing, for years, for months in the building, and that can help you show that this is not something that you caused or you brought to the property. Another thing to note is that if, we have to understand that there's a reality that people can't move sometimes. People can't. There's really a housing shortage.
Financial implications?
Absolutely. Moving expenses. There's an affordable housing shortage. And so if it becomes where you need to stay, if you do take on the treatment yourself, make sure that you're keeping those receipts, providing them to your landlord. The EPA has a really great guide on how to safely treat bed bugs, if that's something that you need to take on yourself.
Is it ever the case that the landlord has the right to try to address the problem before you break a lease or go to that step? Is there like a right to cure? We sometimes hear that phrase.
Oh yeah, that's so interesting. The only language in the statute is promptly repair. So that can be.
What does that mean?
Right, absolutely. But if it's something that's really affecting your health and safety, promptly I think has a more urgent sense to it. And so again, documenting your communication with your landlord, what the landlord's response is, and then contacting the Department of Neighborhood Services or your local building code agency are going to be some of the steps you want to take to help remedy this situation.
Okay, and if you can't get the DNS out there quickly, is that something you hear about sometimes? It takes a while to get an inspector out?
Yeah, absolutely. There's a lot of, buildings in the state, in Milwaukee, that have habitability issues, and so there is certainly a delay in that, in them coming out. Make sure that you're keeping your phone on you. If DNS calls you, respond as promptly as you can. I know it can be difficult with folks who work during the week, but it's really important to document those issues. If the landlord doesn't correct a building code violation within a time frame that DNS gives, the DNS can issue citations to the landlord, which can be a little poke to help incentivize them doing repairs.
Okay, hopefully those answers will be helpful to a lot of people that we've heard to with issues with rodents and with bugs. Annette, what's our next question?
Sure. So Bob in West Allis has reached out to us with the following. A new owner purchased our apartment building and has raised my rent an additional $450 a month. Does Wisconsin have any limits or rent control that addresses this issue?
Okay, this is something else we've heard about. There's a lot of buildings being bought and sold, especially in Milwaukee, sometimes by owners who are not in the state. Would you say there are restrictions legally on whether they can raise rent if there's a new owner coming in?
Unfortunately not. Okay. So state statute prevents municipalities from creating caps on rent on rent raises. This isn't the case in many places across the country. For instance, I believe that St. Paul has recently enacted an ordinance where landlords can't raise rent more than 3% annually.
Huh.
So that's not something that we are able to, gain the benefit of here in Wisconsin, and not in Milwaukee in particular. The median rent rose $100 between May 2023 and May 2024, and Milwaukee is that is that's the seventh highest raise among the largest 95 cities across the country. So it's definitely something that we're seeing a lot of here in Milwaukee and in the surrounding areas as well. Brittany had mentioned before, there's an affordable housing crisis, and we're seeing that in all the rent raising that we've seen. So unfortunately, there isn't any sort of limitation on how much a landlord can raise rent. The only sort of limitation comes from when a landlord can raise your rent. So if you have a year-long lease, landlord cannot raise your rent in the middle of that contract. If you rent month to month, a landlord can't raise it in the middle of the month. They have to give you that rental period amount of notice in order to raise the rent. So they can raise it however much they want, but they can't necessarily do it whenever they want.
So if there is, let's say, a new owner comes in the middle of your lease, they have to wait till the end of your lease? They have to honor the old owner's lease?
That's correct.
Okay. But if you have 6 months left, perhaps at the end of the 6 months, you're going to hear that your rent is going up.
Yes.
And that's just the way the law is.
Yes.
Okay. What do we have next, Annette?
Sure. Again, we have two similar complaints. This time, the issue is about repairs not getting fixed. The first one is from Tina in Milwaukee, and she asks, what do I do if my landlord won't make updates or repairs? We lived in our townhouse for 18 plus years, and when we moved in, everything was outdated. Tina's complaint is lengthy, so I'll paraphrase it. She says her cabinets are falling apart, the kitchen vinyl floors are peeling, and the living room carpet is unraveling. There's black mold in the basement, and her dishwasher and garbage disposal are broken. She says the winters are brutal because there is no insulation in her living room walls. She says they even had a gas leak due to improperly installed pipes, and as a result, her son's father got sick. She says the landlord has threatened to raise her rent if they want anything fixed or updated. Jennifer in Milwaukee, she also has repair issues, and this is her question. I moved into a house and the ceiling is leaking. There is mold everywhere and our landlord won't fix it. I went to community advocates to get help. The electricity shorted out my brand new stove and refrigerator. My landlord wouldn't replace them, so now I'm behind on rent because I had to buy new things. The inspector came and found 16 code violations and the landlord only fixed 4. The kitchen sink is rotten and he won't fix it.
So there's a lot in these two complaints, and they're really heartbreaking to imagine that people are living in these kinds of situations, but we do hear about it a lot, and I'm sure you do too. So I guess there's a lot of questions that I have after hearing this, but what are you supposed to do if a landlord won't make repairs, even if they're told you have to repair these? Here's some violations.
Yeah, so unfortunately, Tina and Jennifer's experience is not uncommon, and we hear this really frequently. As I mentioned before, there's our recommendation is to make sure that you document all communication with your landlord when the landlord knew that repairs needed to be done. Save that if possible. Take pictures when you move in. Contact the local DNS. As in Jennifer's case. They found 16 code violations. That's significant.
That's a lot.
That's a lot. Yeah. So if at this point, both Tina and Jennifer, assuming that they've reported these issues to their landlord, the landlord's not done anything. Now this becomes an issue of they have the right to what's known as abate their rent or withhold a portion of their rent based on how serious and significant these conditions issues that they've documented are. And the theory of that is, sort of based in basic contract, right? If you go to the grocery store and you pay for a pound of bananas, but you only get a half a pound, you shouldn't have to pay the full amount, right? There's
Sure.
something missing there. So in this case, they have the right to abate their rent. And how much to abate can be really tricky. It can be a little bit of a guessing game. Certainly the more that you abate or withhold from your landlord, the riskier it is that they will file an eviction action against you. In Milwaukee, how this works is you would get the DNS order to correct. You would take it to community advocates. Community advocates has a scheme that they would look at each of the code violations and say, this is worth this percentage. Now, the state statute doesn't require that a tenant do that. The tenant can do that on their own and say, hey, based on all these conditions, these 16 code violations, I'm only going to pay you 50% of my rent because that's what this is worth.
And they can legally do that?
Absolutely. Now, if the landlord does choose to evict them, then they'll have to prove that what they paid was the correct amount.
And then you run into the issue of having the eviction filing on your record.
Correct. Correct.
And
Okay.
I do want to mention that, if you are choosing to do this kind of guessing game on your own, there are other places such as Madison and I believe Wausau that have ordinances, so you could search them online, that do have a big scheme that just says if you don't have a working sink, that's worth X% of your rent. So that's another resource that folks can refer to as well. And I would also, recommend that if they are facing being evicted and they have to prove that they did abate a proper amount, there are things that they can reference out there.
Would this be a good idea to contact you about before you abate your rent? Would it be a good idea? Could they get, an opinion from Legal Action of Wisconsin about how to go about doing that?
Yeah, absolutely. Absolutely.
Okay.
Feel free to reach out if you are experiencing these types of issues. Like we said, community advocates is sort of the go-to. They've set a scheme, but and we certainly do recommend that folks contact community advocates if they have a building code violation in order to get their scheme, and they have sort of the institutional backing, right, to help support the tenant. But sometimes, like you mentioned, the building inspector can be delayed, and it can be a lot to take that on. And if you live outside of the Milwaukee County, or excuse me, the city of Milwaukee, you want to contact your local building inspector. Some municipalities don't have, a viable inspector if they're smaller. So again, we would recommend that the tenant, look at perhaps other cities, ordinances and schemes, or feel free to reach out.
And I do want to add one more thing on rent abatement, because I would be remiss if I didn't say that state statute does not authorize someone to not pay 100% of their rent. So you always are going to have to be paying
Something.
a portion of your rent.
Okay, yeah, I've heard of people who said I withheld my rent entirely and now I'm being evicted. So they would have had to withhold a portion. One thing Jennifer said was, my stove and refrigerator shorted out. I had to buy new things. Does that factor into the abatement as well? Something like I had to buy something else to maintain the life I thought I'd have here?
It depends. So
Okay.
these appliances, if the lease says that the landlord will provide them, we would say yes. If they had to incur that cost and the landlord didn't properly fix it, that would be the landlord breaching the lease, right? And the tenant would have a damage based on that. So definitely keep your receipts. If that is the case, check your lease agreement to see what is provided. We are seeing more and more landlords not providing appliances. And that can be a huge cost for tenants to undertake when they move in, to have to buy a new refrigerator and stove. Sometimes we see that tenants just simply can't afford those huge costs up front. And that also becomes a health issue as well. If you're not able to cook meals for your family, you incur, extra costs there as well, and having to get, ready-made meals or takeout.
When it comes to holding the landlords accountable, is that basically DNS and the courts, or is there anyone else that would hold the landlords accountable for addressing these things?
Yeah, so some folks can also make complaints to the Department of Agriculture, Trade, and Consumer Protection if the landlord is, retaliating, raising rent. I believe Tina's complaint says that the landlord has threatened to raise her rent. Now, if that's because Tina's making these complaints either to the landlord about the conditions issues or to the building inspector, the landlord cannot do that. And that retaliation is a defense to an eviction if the landlord were to file an eviction action. And it's also a violation of consumer protection laws. So she could make a complaint to the Department of Agriculture, Trade, and Consumer Protection. And she has the right to sue her landlord for damages. Consumer protection violations allow for a tenant to recover double their damages plus attorney's fees.
Right. Okay. Those questions were great. We got a lot of good discussion out of those too, and I hope they were helpful to people. Annette, who do we have next?
Sure. Greg in Oak Creek, he reached out to us with this concern. My landlord won't install water meters, but charges the entire apartment complex for water. They say it's evenly split, but I don't have children and I use less than others would. There's just me. Other apartments have up to 5 people in them.
So this is an interesting one. I have not heard about this problem before, but can a landlord evenly split a utility bill among everybody in the building, despite how large the different households are?
So the answer to this, as with most of these that we've answered so far, comes from checking your lease.
Okay.
So oftentimes leases will include provisions about who's responsible for utilities. Is the landlord going to pay for water? Is the landlord going to pay for electricity or gas or anything like that? So if Greg's lease says that the landlord will pay for water, then, obviously that's a cost that they need to incur, not the tenants. So that would be, something that they couldn't split or couldn't even, provide to people based on their usage. However, if the lease says that they are going to split it evenly among tenants, then that's what the contract said that they agreed to. If there isn't anything that specifically says it's going to be split evenly, then that could be something that Greg and his landlord could talk about. Like the lease doesn't say that I am going to have to pay as much as somebody else. So what can we do about trying to fix this? But really, these questions are all coming down to what does that contract say that you and your landlord agreed to in the first place? So does the lease say that there's anything that there's any sort of leeway about if there's something that I need to pay or if my landlord needs to pay or if there's any sort of fee shifting in what we owe.
So it really hammers home the importance of reading that whole stack of papers that you sign at the time you sign your lease, right? You really should go through it and see exactly what you're agreeing to, even if it's lengthy and time consuming.
Absolutely.
Okay. All right. That one was nice and short. What do we have for the next question, Annette?
Sure. Katrina in New Berlin, she's wondering if it's her responsibility as the renter to remove 3 large trees that have fallen in her yard due to the recent storms.
I thought this was interesting too. I mean, this could apply to a few things, who mows the lawn and so on. But let's take the trees first. What happens if there are trees that fall on your property? Is it up to you to do it or does the landlord have to?
Yeah, so we would say unless there's a lease provision, again, check your lease. It's probably the landlord's responsibility. The property owner is the landlord, and they might be cited by the local municipality if the trees are at all blocking sidewalks or a safety hazard. So it's probably going to be the landlord's responsibility, unless there's a clause that says that Katrina is responsible for tree care in the yard, but that's really unlikely. Typically, we see lawn care and snow removal. That would be the responsibility of the tenant. But in this case, this is probably the landlord's responsibility.
But I could see how this would be frustrating for someone. Like, let's say the storm happened weeks ago and their landlord hasn't had the time to come out there and remove those trees. If the person's really itching to get those out of the yard, would you recommend they do it? Or would you say, no, you should have the landlord do it?
I think that depends on, Katrina's ability to either pay for a professional or do it herself. If she feels comfortable, she could. I don't see why she couldn't. But I would say maybe, leave that responsibility to your landlord.
Is there amount of time that they should be getting this done in? Or is it come down to the word, promptly again?
Yeah, I think it really depends, unfortunately.
Okay. All right. I think our next question is, let's see, is it Susan's?
Yes, and the questions so far have been from tenants. Susan is a landlord, and this is what she wrote. I'm a former landlord. I have several judgments that I won in small claims court. What recourse do I have to make the tenants pay their judgments if they don't seem to care about their credit and disappear? Did the banks refuse them credit? Why don't the courts make them pay up like child support or fines? I'm retired now and I could really use the money that's owed to me.
All right. I wanted to include at least one question from a landlord because I know that there are financial implications for them too when an eviction is filed, and sometimes these judgments don't get paid. So what recourse is there for landlords if those judgments aren't paid?
Yeah, so this is actually kind of an interesting opportunity for us to shed light on the fact that what happens during the first part of a case, the eviction and the rent and damages, yes, that's landlord-tenant law. But when it comes to collecting a judgment, that's actually an area of consumer law. So this is kind of outside our expertise as housing attorneys because it kind of shifts into a new area of law. So we would really recommend that Susan contact a consumer attorney or a debt collection attorney.
Okay. Yeah, I do know that there can be implications for the tenants in the long term. You know, it could affect their ability to get another apartment. It could affect them if they want to get a loan. So there are implications for them. But for the landlords, it sounds like they would have to consult some attorneys as well. And we do know a lot of court cases from all sorts of small claims issues. They often have unpaid judgments, and that can be very frustrating for people as well. So thank you, Susan, for that question. What do we have next, Annette?
Next is the question from Sonia in Milwaukee. My landlord sends me a 5-day pay or quit notice every 28 days. They tried to evict me a few months ago and had no basis to do so. What can I do about the harassment and constant threat?
Well, this caught my attention. Can you start by explaining what this is, what she's receiving?
Absolutely. So in Wisconsin, if a tenant has breached their lease in some way or they're behind in rent, a landlord can send, typically, depending on the tenancy, but typically a 5-day notice to either pay the amount, cure the breach of the lease, or vacate. And if they do neither, then a landlord can file an eviction action against them, which is an action in small claims county court. So for the 5-day notice here in Sonia's case, she's saying, and I think this is what she's saying, is that she's paid her rent timely. These seem to be getting mailed to her in error. Or maybe she's paying, maybe her rent is due on the 5th. She's paying on the 4th, but the office actually doesn't receive it until the 5th. So an automatic notice maybe is going out to her. If Sonia is paying her rent timely, she doesn't need to really worry about this. She could treat it as junk mail. But if Sonia is behind, let's say rent is due on the 5th and Sonia receives this notice on the 7th of the month, Sonia's going to want to make sure that she pays that amount within that 5 days.
That's where that right to cure language that you're hearing a lot probably comes in, because tenants have a right to pay their rent within that 5-day period.
Okay, that is interesting to me. So let's say she is up to date on her rent every month. Is it harassment to send this every month, or can they do that?
Again, it would depend on the facts here, when it's getting received. Our recommendation is to just treat it as junk mail. There's nothing that would prevent a landlord from sending notices, unfortunately.
So as Brittany had mentioned, a lot of management companies do have that automatic system. So if they don't have the rent in their system by a certain time, those notices get sent out automatically. So it may not necessarily be even an intentional thing that they're doing. It can be, kind of frustrating, but yes, as Brittany said, it would be something to just, as long as you are paying your rent, it's something that you don't really need to necessarily worry about.
All right. Thank you, Sonia, for that question. We have another one.
Yeah, this one is from Faith. She did not provide the city where she lives, but this is what she'd like to know. If you are a renter, can a landlord charge you for solar panels when they are leasing them? If so, am I entitled to see a receipt? Also, can a landlord keep storage at the place where you rent? Am I, the renter, able to charge them a storage fee?
So there's a couple issues there. When it comes to being charged for the solar panels that this landlord is leasing, does that come back to the contract again, or the lease, or how have you seen this before?
I have not seen this before,
Okay,
but
one.
But it sounds like you're catching on to the theme here.
Okay.
So if there is something in the lease that says this property contains solar panels and that is something that you as the tenant are going to incur as part of your rent, then yes, that is something that Faith would have to pay. If she wanted to see a receipt, she can certainly and should ask her landlord to provide, what are you actually being charged for this? Can I see that and everything? Like if a landlord's just sending her an invoice or something like that, and she wants to see what it is, then she should absolutely ask, and the landlord should have no problem with providing that to her. But if the lease doesn't say that she's responsible for utilities at all, or even if it doesn't necessarily mention the solar panels or anything to do with electricity generating or anything like that, then I would say that probably isn't something that's her responsibility.
So if her landlord says, sorry, too bad, would she talk to you guys about it, or would she go to community advocates?
I think that could be something that she could talk to us about for sure. I wonder, that would be something that she would want to, negotiate with her landlord about.
I assume it's always better to try to settle it with the landlord rather than having to go and bring in a third person. Is that usually preferable?
Sometimes.
Sometimes, some case, sometimes
depends.
not.
Yeah. Yeah, it really depends, I think, on the situation. What is the tenant's preference? What's been their relationship? How long have they lived there? There's a lot of that factors into, what makes the most sense for the tenant and their goals.
And that's certainly something that we can talk through at the very least, that, a lawyer might not even need to step in, but could at least talk through those interests and help someone in that way.
Okay, wonderful. There was a second part of this question involving storage at her home. What do you make of that? Is a landlord allowed to keep storage at your home? Can they just drop off stuff whenever they feel like it? How do you feel about that?
So that's another thing where you would want to check the lease first and foremost. That is something that sometimes you see, particularly if you're renting like a single family home and the landlord who owns the property has kept stuff in the basement or something like that. But you'll want to do an inspection of the place when you move in. Like when you moved in, was there a bunch of stuff that doesn't belong to you in your space? You'll want to take pictures of that, make sure that the landlord knows like some stuff is here and it is not mine. Like, is it yours? Is it the last tenant's? What do we do about this? Can we get it removed? And if the landlord's like, yes, this is my stuff, that's something that I keep there, then that's probably something that just sort of, happens throughout the tenancy. But, something that landlords need to understand and that tenants need to understand is that when you enter into this contract and that when you are moving into a place and you are renting from someone, you're the tenant, that is where you are living. Like you have possession of that property. You don't own it, but you are living there. So if the landlord is, coming into your space without notice, they have to give you notice before they enter into the space. So they can't just drop things off and encroach on your space if there's nothing in the contract that allows them to do so.
So if they came by and dropped off a bunch of tools or something, are they allowed to do that if it wasn't there to begin with?
It sort of depends on kind of what the space is. So if you're living in a large apartment building and the landlord keeps tools in the basement or in the garage of that, and it does take up considerable amount of space, but it's not necessarily affecting your living, then yeah, they can probably do that. But it's kind of a different situation if, you're living in a single family home and they are just putting a bunch of stuff on your porch or something like that. But that's, again, something that you want to perhaps talk through before taking any sort of action.
All right. Moving on to the next question. I think it's Dion.
Yeah, from Milwaukee. During COVID, my previous landlord failed to send in a form that was vital in keeping my Section 8 rent assistance voucher. I feel it was done on purpose because of some derogatory things that were said about my economic status. As a result of this, I got behind and moved. Since then, I've been subjected to substandard living and struggling to find funds every month. I survive on Social Security and kinship because I'm raising my grandchildren. I've exhausted myself trying to find help from every avenue. I was accepted into the Waukesha Housing Authority, but a week later received a letter stating that funding was cut, so I would be on the list indefinitely. How do I get my benefits back without being on a lottery list and having my name drawn out of a hat?
Yeah, we hear quite a bit about rent assistance benefits and people who aren't qualifying for them. So how do people go about getting rent assistance benefits?
Yeah, so Dion's question highlights, again, this overarching need of affordable housing and the lack of affordable housing available to folks. Dion, it sounds like he's doing everything right. He's on the waiting list. He's applied, making sure that, he's just keeping contact with the housing authority, seeing if they can provide him any update on where he's at on the list. Dion's point also talks a little bit about Section 8 rent assistance, and I did want to maybe talk a little bit about what that means. And so that's a benefit that provides a subsidy. So basically, Dion likely would only pay 30% of his income towards his housing costs. The housing authority would pay the remaining balance towards his rent. With a Section 8 voucher, it means that you can live wherever as long as the landlord will be willing to accept that Section 8. That voucher, those funds from the housing authority. Unfortunately, we've seen a lot of landlords who are unwilling to take Section 8 vouchers, and due to the requirement that there be an inspection on the property by the housing authority. Sometimes there's delays in payment from the housing authority to the landlord. So unfortunately, we're seeing a really big issue where folks have this Section 8 voucher, but they're still not able to find housing because they can't find a landlord who's willing to rent to them. So that's one type of rent assistance. Another type could be site-based or what's otherwise known as public housing. So if you apply to an apartment building where it says maybe you only pay 30% of your rent, that could be a subsidy or rent assistance for that particular property, whether or not it's owned by a private agency or by the public housing authority, depends. But that doesn't move with you. So if you leave that building, unlike a Section 8 voucher where you can take, wherever, in theory, that voucher, that rent assistance stays with the property.
Are you finding there are fewer benefits available? Because I know during COVID, there were more benefits available for some people for rent assistance, for example. Is that hitting people a little bit now that we don't have that anymore?
Absolutely. So during the pandemic, there was a large amount of funds that were coming in to help people who, were laid off, had to stay home with kids, couldn't work because of that. And so there was this emergency rent assistance that helped cover people's rent. That's gone now, but people are still facing, unexpected lapses in income. If you lose a job unexpectedly, if somebody that you're providing care for, either a child or a parent or a family member, gets sick, if you yourself get sick unexpectedly and need to take unpaid leave, people are still experiencing these situations, and unfortunately there's not as much of a safety net there as there was during the pandemic.
I will say on a positive note, though, there is another kind of rent assistance that is it's tailored to folks who have minor children. So it's given from the Department of Children and Families. It's called emergency assistance. And that, for the longest time was $560, a one-time payment that the landlord would need to accept. And otherwise, it wouldn't be something that you would get. The landlord would have to agree to accept it. That has increased, actually. It's nearly doubled to, I think, like almost a little bit over $1,100. So that can actually cover someone's monthly rent. So, that I do want to highlight a positive note on rent assistance where we can get it.
Okay, that's great to know. Our next question, Annette, comes from someone in Wauwatosa.
Constance, yes. This is what she wrote. I live in an 8-family apartment building. My landlord is making me and my daughter move within 60 days. We are up to date on rent and have no complaints about us as tenants. Do we legally have to move?
And I will point out, I had a typo in this question when I kind of sent it to you earlier. So it's an 8-family building. I told you it was an 80-family building. So does that make a difference? And I guess the question there is, can a landlord force a 60-day eviction without cause?
So I will say that the number of families in the apartment doesn't really have.
It doesn't make a difference?
Not in this case. So this is pretty fact dependent here, this question. So, I would first want to know, does Constance have a year-long lease? So if she has a year-long lease and she's in the middle of the term, and it's not going to be up in 2 months, the 60 days, like she just moved in or something, or she just renewed or something like that, then, without cause, the landlord cannot force her to move out. You can only break the contract if she's broken the contract. So if she didn't pay her rent, or if she, did some sort of other breach of the lease, then that would be the only time that a landlord could try to evict her for that. In this case, let's say that she has a month-to-month tenancy, like she just pays monthly, and, sees how it goes, pays another month. The landlord could give this 60-day notice without cause. They don't have to have a reason to choose not to rent again for a month-to-month tenancy. The same is true, in a third set of circumstances. Let's say that Constance does have a lease for a term such as a year. However, the lease is going to be up soon. It's going to be up in 2 months. That's when the lease ends. That is not an eviction. That's just the landlord choosing not to renew her lease. So there is a difference between that. A landlord does not have to renew someone's lease. That is, again, something that you want to check your lease for if there is some sort of term or, condition to renew the lease. But for the most part, there is just no obligation to renew a lease. So if her lease is going to be up in, 60 days from now, that is the landlord's, prerogative to choose not to renew. And it's not an eviction, it's just a non-renewal. Not to say that perhaps the consequences are that much different. She would still want to move within that period, or else she would face the landlord potentially filing an eviction because she is what's called holding over, staying past a lease that has canceled or not been renewed. But, it's not something that she's receiving an eviction notice for that she should be worried about, like the consequences or the conditions that a landlord needs to follow to file an eviction.
All right, we have just a handful of questions left, and hopefully we'll get to all of them. What's the next one, Annette?
Yeah, this one's from Peggy in Milwaukee, and she would like to know, what can you do about a neighbor doing illegal things? My neighbor has climbed on my roof and removed bricks from my chimney without permission. His kids climb on and in my tree after I told them not to. The parents hung a climbing rope on my tree. They are renters, not owners. They start huge fires with gasoline. Is there anything that can be done legally to prevent some of this?
So I know a lot of us are familiar with neighbor complaints, right? It doesn't matter if you own the house or if the people next door are renting. Not getting along with your neighbor can be really difficult for a family. So what can be done if your neighbors are renters and they're doing something that they're not supposed to be doing?
Yeah, so Peggy has the right to contact the owner of the home, the landlord, the parents of the children, and she also has the right to contact local law enforcement.
Okay. And the next one's pretty short too, Nanette. Let's see if we can get a quick answer to this one.
So Aaron in Ellington is seeking an answer to this question. How much time does a landlord have to fix something like a broken washing machine?
Well, we've talked a bit about this before, so first things first, check the lease. Does the landlord provide washer and dryer? If they do, it comes back to that question again of what's reasonable, what's prompt, things like that. I do want to make one quick note, though, that, if a landlord does make a promise to repair, like if they do say, I will repair this within 2 weeks, and then they don't, and they don't have a good reason for that, that is something that is also a violation of consumer protection under the administrative code that we had referenced before. So keeping track of the costs that you incur when a landlord breaks a promise to repair and they don't have a good reason for it, and again, it's an excessive amount of time after that, that's something that you can, recover costs for.
All right. And did you have something you wanted to add before we get to our last question?
I was just going to say that if the washing machine is agreed to be provided by the landlord and it's not usable and the landlord's not repaired it, that Arent does have the right to abate her rent for the loss of that.
Good to know. All right, Annette, we're going to get to one more today.
Okay, the last one is from Savannah in Milwaukee, and this is her question. I've been dealing with sexual harassment from the maintenance manager at my apartment. I have concerns about the maintenance manager entering my home without permission. When I brought these concerns up with management, my work orders stopped being completed. A few months later, the maintenance manager was fired, but none of my issues were addressed. Do I have a case? I have pictures and text messages.
Okay. So this raises a couple of questions. Let's start with the entering of the property without permission. Can a maintenance manager do that?
Unless the lease states otherwise, the law is that 12 hours written notice must be provided prior to entry, unless the tenant consents to an earlier entry or unless there's an emergency that would require the landlord to enter. So in this case, it sounds like perhaps maybe written notice was not given before maintenance entered.
Okay. And when it comes to sexual harassment, I have to imagine that you hear about that from time to time. How would people go about handling that?
Yeah, so these stories are really unfortunate to hear, but unfortunately also not uncommon. In this case, Savannah has the right to, if the harassment is continuing, to pursue a temporary restraining order against the harasser. She might have the right to other like civil remedies, depending on the nature of the harassment. She also has the right to file a HUD complaint, which is the Department of Housing and Urban Development, for the harassment that she experienced, presuming that the maintenance person was acting on behalf of the landlord.
Okay, well, that is all the time we have for today. So if you would like to submit a question for a future Ask Contact 6 segment, we have a QR code that you can scan. You can also go to fox6now.com and click on the blue Ask Contact 6 button on the screen. The next topic we will be discussing is something we're going to announce later. We've got some good things planned. Abrielle and Brittany, thank you so much for being here today. This was really informational and really helpful.
Thank you for having us.
Absolutely.
Of course. So thank you to all the people who made this recording possible, including our executive producer, Sarah Smith, our editor, Dave Machuda, and our chief photographer on the video switcher, Kale Zimney. I'm Jenna Sachs. Thanks for joining us.